Hi everyone, you're watching the Virtual Amicus and I am Jay Ludha. So today's topic for discussion would be on criminal cases that are based on circumstantial evidence and what we mean by presumption under section 106 of the Indian Evidence Act, as well as interesting facets of section 34 read with section 149 of the Indian Penal Code. Now, what do we mean by presumption in the first case? Broadly speaking, presumption of innocence would mean that any defendant in a criminal trial is assumed to be innocent until they've been proven guilty. Now, it's a legal principle which is based where our Indian criminal law is, mostly based on. And in simple words, it would mean that every person accused of a crime is considered innocent until he's proven guilty. And when I mentioned about section 34 of the Indian Penal Code, I refer to the acts that are done by several persons in furtherance of a common intention. And I will pause here for a minute. There has to be a criminal act or a criminal commission of an offense to that extent. Now, what do we mean by section 149? It means that every member of an unlawful assembly is guilty of offense which is committed in prosecution of that common object. Now, to assist us better, we have with us a very dynamic, distinguished lawyer who's joining us from Chandigarh. We are joined by Mr. Vipul Joshi. And just to give you all a brief introduction about our amicus for today's session, Mr. Vipul Joshi is qualified as a lawyer in the year 2015 from the prestigious Government Law College, Mumbai. And he went on to work with disputes resolution team at the Delhi offices of Khaitan and Company, India's biggest and oldest law firm. During his 2-year stint with the law firm, he appeared before various courts and forums in Delhi, as well as before various high courts across India, and also advised various corporate houses on matters involving commercial, contractual disputes, employer-employee disputes, white-collar crimes investigations, etc. Having decided to come back to his hometown, he set up his chambers in Chandigarh and has been practicing primarily before the Punjab and Haryana High Court and the National Company Law Tribunal at Chandigarh for the past 4 years. And criminal law is something that fascinates him the most. And that's what he's going to be joining us today to talk about, to elaborate further. So thank you so much, Mr. Joshi. So sorry we spoiled your Sunday evening plans. I mean, I'm sure you could have done something more constructive and something more happening and fun than to be on our channel and discuss presumption and section 34, etc. and etc. Anything that you wish to say before we start with our session?
Thank you so much, sir. It's a privilege to be here. The stellar lineup of speakers that you've had on your channel makes me a little nervous. But I would like to add one bit of my introduction, which you missed out, is that, you were a senior in college and a source of inspiration throughout our college life. And that's one bit that you missed out when you were introducing me.
Thank you so much, Mr. Joshi. I don't think I can ever, fit in the shoes that were probably the kind of standards that our seniors have set, the illustrious alumni that has passed out from the Government Law College, Mumbai. So I hope and I wish that speakers and, who come and appear and feature on the virtual amicus keep inspiring everybody, inspire a generation of lawyers to come. Because this period, this time has been tough for everybody. So it is so important to come out, to share your experiences, to share whatever you've garnered, you've earned over the years in the form of knowledge, in the form of experiences, the lessons that you've learned in the journeys that you've undertaken. So thank you so much, Mr. Joshi, for all the kind words. It really means a lot to me and my team. And so, sir, the stage is set. The floor is all yours. Over to you.
Thank you so much. Sir, although you've already summarized the topics that I will be covering, but I will still take 30 seconds to only, kind of list them out in slightly greater detail. The first section that I'll be speaking on is, of course, criminal cases based on circumstantial evidence, as against, cases which are based on an eyewitness account. I'll be covering a few important facets of such cases. I will also talk about circumstantial evidence with specific reference to section 106 of the Evidence Act in particular. Since that is somehow, related to the broad topic of circumstantial evidence, so to say. Next, I will be talking about section 34 and 149 of the IPC. These are two sections which are often, seen in FIRs whenever multiple accused are involved in a particular case. However, I will be discussing about, relatively less talked about facets of these two sections, which will be primarily with relation to a free fight, when a case involves a free fight between two factions, two fighting factions, and another one where unlawful assembly is not proved. What will be the effect on the applicability of Section 34 and 149 in such cases? A small disclaimer, since these topics in my view are certainly not as interesting as the other topics that you've had on your channel, I will try to keep it very, very short. So moving on, criminal cases primarily are based on either circumstantial evidence or an eyewitness account. When cases are based on an eyewitness account, of course, the threshold that the prosecution is required to meet is relatively lower, in the sense that we have an eyewitness account of a person who have seen the occurrence with his own eyes. So as far as his evidence of what he has witnessed is of sterling quality, even a solitary eyewitness will be sufficient to bring home the guilt of the accused and return a finding of conviction. However, that's not the case when a case is sought to be proved on the basis of circumstances, and there is no eyewitness to the occurrence which is sought to be prosecuted. Circumstantial evidence, of course, makes the task of the prosecution much taller, since the expectation from the prosecution is to prove the guilt of the accused beyond reasonable doubt, as is the case in every criminal case. But apart from that, there is a clear-cut chain of evidence that they ought to establish when they are relying upon circumstances. So what the Supreme Court says is that even if a single chain or a single link out of the chain goes missing, then the benefit of doubt ought to go to the accused. And it will not be appropriate to convict somebody based on such evidence, which probably experiences some missing link in the chain that is sought to be proved. As far as circumstantial evidence is concerned, the landmark judgment of the Supreme Court is, of course, K.T. Palanisamy, etc. But later on, in the case of Sharad Birdi Chand, a detailed discussion was held. I will only read out the 5 golden principles, as the Supreme Court called it, as far as cases on circumstantial evidences are concerned. It said that, firstly, the guilt of the accused should be a matter of, certainty. It should not be that, it seems that the accused has committed the crime which he is charged with. It ought to be the case that, it is a case where he has certainly committed the crime that he's being charged for. That's one. Second principle is that, the facts so established by way of using all the circumstances which surround the case should, be consistent only with the hypothesis of the guilt of the accused and with no other hypothesis. So every circumstance taken together or even individually that the prosecution seeks to, further in a particular case ought to, lead us only to the guilt of the accused and to no other thing. Thirdly, they said that, the circumstances should be of conclusive nature and tendency. There shouldn't be any nature of inconclusivity attached to the evidences that are sought to be led as circumstances. Fourth, they said that, every possible hypothesis except the one leading to the guilt of the accused should be proved to have not been made out in the particular case. In their words, they said that they should exclude every possible hypothesis except the one which leads to his guilt. Lastly, the broad principle that they laid down was that, the chain of evidence should be so complete as to leave absolutely no reasonable doubt which could be inconsistent with anything but the guilt of the accused. So these were the 5 golden principles which were held to be the guiding lights so far as, appreciating evidence in a case based on circumstances is concerned. Largely speaking, there are 3 or 4 kinds of circumstantial evidences which are often pressed into service by the prosecution and which are often seen to be present in cases which are based on circumstantial evidence. The first one is popularly called the evidence of last seen, which essentially means that, the accused and say the victim who probably was murdered were seen together, were last seen together. In other words, before the deceased met his end, he was seen with the accused. However, the evidence of last seen is not a very strong kind of evidence, because there are other aspects which are supposed to be considered before you rely upon the evidence of last seen in order to convict somebody. The most important one being that the time duration between the time when the accused was last seen with the victim and the time when the victim was found to be dead is so little, or is so short, that it does not permit for any change in circumstance, so to say. It does not permit for the involvement of any other person, except that of the accused. So a lot of times last seen evidence is pressed into service, but what we have seen in our experience is that the time duration is such that the benefit is often given to the accused, because of the fact that it kind of boils down to there being a possibility that between the time period when he was last seen and when he is said to be murdered, there was a large possibility of a third party or a third person to have gotten involved in the offense, so to say. So in such circumstances, the last seen evidence is not taken to be foolproof evidence of the guilt of the accused. The second kind of circumstance which is pressed into service as an evidence is that of motive. Earlier, motive used to hold a lot of importance in criminal cases based on circumstantial evidence. However, of late, the Supreme Court, in so many of its judgments, has moved away from relying upon the evidence of motive to a great extent. This flows from some of our jurisprudence, which goes to say that the human mind is very unpredictable. So therefore, there are things which could be committed without any motive also. And also, even though somebody may have a very strong motive to commit a particular crime, that may still not be enough to motivate him to actually commit it. So therefore, motive, by and large, has of late been considered to be something which is not very critical for the prosecution to establish in a case of circumstantial evidence. The third kind of circumstance that is pressed into service often is that of an extrajudicial confession that the accused may have made. Now, of course, confessions, when we talk of confessions made to a police officer or in custody, those are not admissible under the Evidence Act, because they are made to a police officer in custody, and he has a position of power over you. And a lot of times it is considered that those confessions are not made voluntarily. So therefore, they are inadmissible in law. They may, of course, still be made part of the entire story that the prosecution is pressing into service. But they, by themselves, such confessions are not admissible. However, a different kind of confession by an accused, which is admissible, there is no bar on its admissibility per se, is that of an extrajudicial confession, which essentially means that the accused has confessed his guilt or the fact that he committed the particular crime that he is charged for to a third person, who is neither a police officer nor any other person who's in any position of authority over the accused. So extrajudicial confession is often used to complete the chain of evidence against the accused in a case based on circumstantial evidence. However, a lot of times, even such evidences are set aside by the court as far as their reliability is concerned. A couple of things which are considered before one can base reliance upon an extrajudicial confession is that one, whether it is natural, whether it was natural for the accused to make the extrajudicial confession to the person that it is stated to have been made. For example, if the witness of extrajudicial confession is supposed to be a person who I'm not familiar with, nor am I intimate with, or nor do I trust, or nor do I have any history with. So in such circumstances, it will be looked at with suspicion. It will be looked at with an evidence which cannot be relied upon safely. However, if the person who's giving the evidence of an extrajudicial confession having been made to him is a person who is a natural confidant of the accused, then of course a higher evidentiary value will be attached to it. For instance, if, for example, my mother were to make, were to be a witness in order to state that, her own son came to her and confessed to the crime that he's committed, then of course that's the kind of extrajudicial confession which will be taken seriously and which will be attached with a lot of sanctity. This particular point reminds me of this one murder appeal that we were, doing before the Punjab Haryana High Court. In that, the prosecution relied very heavily upon a particular extrajudicial confession that the accused was stated to have made. However, it turned out that the confession was made to a person who was completely a stranger to the entire factum of things involved in the case. Neither was he known to the accused party, nor was he known to the complainant side, nor was he known to the victim. He somehow just came out of nowhere and stated that an extrajudicial confession was made before him. In that case, the trial court disbelieved him on that count, and the High Court also upheld that finding of the trial court, since it was held that it is unnatural for the accused to have possibly made that confession before such a person who otherwise is a complete stranger. So there was no occasion for me to go before him and make that confession, even if I wanted to. Lastly, of course, there are other things as against an eyewitness account. It could be an electronic evidence, it could be fingerprints, it could be phone call records. It could also be my tower locations. A lot of times the prosecution uses my phone's tower locations to establish the fact that I was at the particular place at the relevant time when the crime was committed. So these are broadly, the kind of circumstantial evidences which are present into service. And now this takes us to section 106 of the Evidence Act. It's just 2 lines. I'm sorry, I'm not screen sharing, but I will just read it out for everyone to just get familiar with it. It says, burden of proving fact, especially within knowledge. It reads, when any fact is especially within the knowledge of any person, the burden of proving that fact is upon him. Now, this is a slight departure from the general principle that it is the responsibility and the sole responsibility of the prosecution to establish my guilt. Now, this section under the Evidence Act is a slight departure from that, insofar as it fastens some responsibility on me as an accused also to prove a particular fact which is stated to be in my particular knowledge. The kind of cases where 106 comes into service typically are cases where crimes are committed within the 4 walls of a house, often, in a lot of cases against women, crime against women, whether it's a case of 304B, which is, of course, dowry death, or even cases of murder, which are stated to be committed within the 4 walls of a house and with all the 4 doors locked, so to say. These are cases in which the accused is expected to, put forth some explanation as to what may have happened. So, for example, if in a house, it is the husband and the wife who are present at night, admittedly so, and in the morning, the wife is found murdered, then there is possibly no chance for the prosecution to establish at least as to what exactly happened, beyond reasonable doubt. So in such cases, section 106 will be pressed into service, and the accused will be made amenable to this section, and he will be expected to put forth some explanation as to what has happened, because it is just the 2 persons who are within the 4 walls, and in the morning one is dead and one is alive. So therefore, in such circumstances, the burden of proof shifts upon the accused, as against everything else in which the burden continues to be on the prosecution. However, in my experience, section 106 is often applied a bit loosely also. The prosecution often tends to, raise its hands on everything else that it is otherwise required to do by relying upon section 106. They simply say that, it is within the 4 walls, 106, he ought to explain, he can't explain, so therefore his guilt is established. It is not that simple, because 106 does not have the effect of doing away with 101 of the Evidence Act, which defines burden of proof, which of course largely says that the burden of proof is upon the person who makes a particular assertion. So if the prosecution is making a particular assertion of my guilt of having committed a particular crime, then the burden of proof under 101 continues to be on the prosecution. It is just that section 106 and my explanation or the lack of it may be used as an additional link in the chain of evidences which are used against me in a case of circumstantial evidence. Now, so again, coming back to another case that we happened to argue before the High Court. In that, the prosecution sought to rely upon 106 in a case where the crime was committed in a car. However, the car may have been logged from all sides, but the car was out in the open on the highway. It was a husband and wife. The wife was found dead and the husband was found unconscious, admitted to a hospital. He was, of course, charged with the murder of his wife eventually. 106 was used to expect him to explain as to what has happened in the car, irrespective of his state of being unconscious. The defense that we took was that 106 will not be applicable to this case, especially because this is not a case which is a circumstance which does not admit of anybody else's presence. It is a highway, it is an open highway, it is a car which is on the highway, so therefore 106 would not be applicable at all. Although the conviction from the trial court was largely based on their reliance upon 106. So we were able to successfully have the conviction reversed on the ground of 106 being inapplicable, among, of course, all the other grounds that we took against the conviction. Now, again, in a slight relation to 106, a lot of times the prosecution tends to rely upon the lack of explanation that the accused may give of a particular fact. Now, what the Supreme Court has held, that the lack of explanation or the lack of plausible explanation by the accused by itself will not be sufficient to establish his guilt. It will not be a circumstance which is sufficient to convict a person in a case based on circumstantial evidence. It will only act as an additional link as long as all the other links are stated to be intact and they make a clear-cut case of guilt having been established against the accused. Then the lack of explanation or the lack of a plausible explanation on part of the accused of a fact which is required to be in his personal knowledge is considered to be an additional link. However, a lot of times an explanation which the accused has given may not be very believable, but at the same time, it is not the kind of explanation which can be conclusively stated to be false. This again brings us back to a case in which the accused was himself found to be unconscious and was, of course, arrested from the hospital, but was later charged with the murder himself. Now, what the court held was that the fact that he was unconscious, because of course the prosecution was trying to prove that he was faking his state of being unconscious, and it was him who had murdered his wife, and later he set up the entire scene and caused injuries to himself and got admitted in the hospital. However, what was seen was that whether any medical record was led in evidence to state that the doctor found him to be faking his state of unconsciousness, or whether he was not unconscious by the time he reached the hospital. So since there was absolutely no evidence impugning his claim of being unconscious, that explanation on his part was found to be an explanation which cannot be conclusively stated to be a false explanation, so as to render any benefit to the prosecution. So any benefit that the prosecution sought to obtain out of this explanation of mine was held to be not available to the prosecution. That brings me almost to the end of the section on circumstantial evidence. Next, I would like to talk a little about section 34 and 149. 34, of course, all of us know is common intention. It states that if common intention is proved amongst a group of people or people who are more than one, and a crime is committed in furtherance of that common intention, then irrespective of who actually has acted in pursuance of that common intention, each and every person who's part of the group of people who were the accused will be equally liable for the act committed by any one of them. Once the common intention is established, it does not matter thereafter as to who fired the shots, in other words, if I may say so. 149 is also similar. 149 talks of unlawful assembly. Once an unlawful assembly is proved, then quite similar to 34, it states that even if the act is committed by only one of the members of the unlawful assembly, each member of the unlawful assembly will be equally liable. For example, if 5 persons constitute an unlawful assembly in a field, and only one of them fires the bullet which causes the fatal blow to the victim, then all five of them will be convicted for murder with the aid of section 149. 34, of course, does not require an unlawful assembly, which of course requires a particular number of persons which ought to be present. 34 can be applied even to two persons, and if only one of them has, committed the actual act which resulted in the crime being committed, both of them will be equally liable for it. 34 and 149 is often present into service very casually, and a lot of times for the accused who have not been attributed the particular assault, so to say. A lot of times defense lawyers miss out on a particular defense that is available to them in cases where 34 and 149 is applied, is a case where the occurrence is in the nature of a free fight, which essentially means that 5 persons on one side, 5 on the other side, they clashed, and it resulted in the murder of one of the persons and injuries having been caused to the others. Then with the aid of 149, ideally one would think that all 5 of them would be liable for murder and nothing short of that. However, the law is that if it is a case of a free fight and both the sides have received injuries, then 149 or 34 will not be applicable at all. That's because the rationale behind this is that when the occurrence is in the nature of a free fight, then one cannot really say as to who was the aggressor and who exercised the right of self-defense, because both the sides have received injuries. So in such circumstances, the fiction which is created by 149 and 34, I call it vicarious liability under criminal law. Otherwise, of course, the concept of vicarious liability is absent and alien to criminal law. But 34 and 149 are two sections which kind of have this effect on an occurrence where somebody is held to be vicariously liable for having committed the murder, even though he may not have fired the shots, essentially. So in a case of free fight, once these two sections go out, then each individual will be liable for the individual act that he committed. For example, if Ram is accused of having fired the shot, then he may be convicted of the offense under 302, which is of murder. However, his accomplice, who only rendered, say, a lathi blow to the accused, which to the victim, which resulted in a simple injury, then irrespective of death having occurred on the other side, and they being otherwise a part of an unlawful assembly, so to say, he will be convicted only for 323, which may be a simple hurt and punishable with just a few months, practically speaking. Another circumstance in which 34 and 149 goes out of consideration is a case where the unlawful assembly, as alleged, is found to be constituted on land which belongs to the accused. Now this brings me again to a case which was argued in our High Court. This was long ago, and my senior, of course, shared this story with me, and I share it with a lot of people. I find it very interesting. It was that two factions in the village had fought, and there was a death that took place. 24 persons on the side of the accused were charged with murder with the aid of 149 and 34. Now, all 24 of them were convicted for murder. And back in the day, the concept of rarest of rare cases was not there. So for the offense of murder, invariably, the punishment would be phansi, as they would call it, to be hanged till death. So this was a village in which 24 young boys were convicted for murder and were sentenced to death. This very famous lawyer in Chandigarh, Sardar Dara Singh, he was a doyen of the criminal bar in our High Court, was arguing the appeal. As it would play out, the appeal was concluded in 30 seconds, is what I'm told. What Sardar Dara Singh did was that he relied upon the site map of the place of occurrence, where the incident was stated to have taken place. He showed point A and he showed point B. Point A was where the 24 young boys gathered and fired a shot, 2 persons who were at point B. Now, as per the site plan, what he was able to establish was that the place on which the 24 persons were standing and fired the shots from belonged to the accused persons. So they were on their own land, which meant that 149 will not be applicable because I cannot constitute an unlawful assembly on my own land. That's the law. The Supreme Court has also held it in one of these cases. I will share the citation with you later. Unlawful assembly has to be, of course, at a public place or at a place which, in the very least, does not belong to me. So in that case, Sardar Dara Singh was out from the High Court in 30 seconds. One of the 24 persons was, of course, convicted for 302. His conviction was maintained. All the other 23 were acquitted because there was absolutely no other injury that anyone else had caused to the other side. So that's one interesting case that my senior shared with me, and I like to share it with everyone, that in 30 seconds, with the aid of this concept of the non-applicability of 149 to a case, where the unlawful assembly, as alleged, is found to be, on my own land. 23 persons were found to be, acquitted, and one person was convicted, of course. So yes, lastly, the one principle that I missed out on was, the concept of benefit of doubt. In a case of circumstantial evidence, of course, the concept becomes all the more relevant because, like I said, even if a single link in the chain of evidence is found to be broken, or is found to be missing, or is found to be unreliable, then the benefit of doubt is held to be liable to be given to the accused. Now, this again takes me back to another case which was argued before our High Court, and I was told about it, was that once one of our former advocate generals was arguing a criminal appeal, and as things would stand, the bench was not inclined to, was not impressed by the arguments being taken on behalf of the defense. So there was a comment which fell from the bench. I mean, it was off the cuff, but of course very significant considering the outcome that it resulted in. The bench said that, Mr. So-and-so, the story propounded by the defense is even more unbelievable than the story propounded by the prosecution. The counsel shut his brief and he said, "I rest my case." So the bench was a little perplexed as to what has happened, because the appeal was expected to go on for a while, and the evidence was yet to start, and the marshalling of evidence and the appreciation of evidence was yet to start. So the counsel shut his brief and he said that I needn't say anything else, because the moment my lords have said that the story of the prosecution is also unbelievable, then notwithstanding the fact that my defense is much more unbelievable, I deserve an acquittal. I deserve the benefit of doubt to be given to me. So with that, sir, I think I will end my session. I promised to keep it short. And if you have any questions on absolutely anything, most welcome to shoot.
Thank you so much, Mr. Joshi, there for your valuable insights. So I must compliment you on a brilliant presentation. You've always been this really very passionate, and the passion that you have for advocacy and this fire in the belly that really showed, displayed, and that you portrayed. And I'm at peace with whatever you said. So I had some 5-6 questions that I had framed before the beginning of the session. But then, you've answered all of them beautifully, especially with these anecdotes and stories that you shared of these doyens that, who had argued and presented these matters. I think this channel is about those experiences that the senior had shared with you, and you sharing it with all the viewers. I think it will definitely benefit all the viewers who are watching this. So to all the viewers, once again, our email is mentioned on the channel. So in case of any of the queries that you have on fundamental, basic concepts with respect to what presumption of law, what presumption of fact is, or what unlawful assembly is, feel free to write to us. We'll be more than happy to forward the same to our amicus for today's session, Mr. Vipul Joshi. Will be always willing to assist you and help you out, or you can even directly mail me all your queries and I'll forward the same, or you can independently write to Mr. Joshi, the amicus for today's session. So thank you so much, Mr. Joshi. Once again, anything that you wish to say towards the end of our segment before we wrap it up?
Thank you so much, sir. It was an absolute honor to be here. Thank you so much.
Thank you so much, Mr. Joshi. Once again, next episode is on its way. Stay tuned. Stay tuned for all the updates. COVID is still around. Take good care of yourselves. Take good care of your loved ones. It's goodbye for now. Thank you, Mr. Joshi, once again.
Yes, sir. Thank you.